he did a living will, a pull the plug document, but guess what? His living will says, when the time comes, I leave it up to my family members. Oh, that is so lame.
Not
Because
right. Not
no,
right. No.
when we do a living will, which is standard procedure, we actually name
Who?
who would
Who?
make that decision for you.
Correct.
I go family members. Well, who's that going to be?
What's
Your
it, right?
estranged kids, your brother, sister, nieces, nephews, cousins? I don't know. She goes, Tom, she did all these forms for me. She put my friend's name in all these forms. Why would she have not put her name in the living will declaration?
Why?
He didn't know, and I didn't know. Just lame drafting.
You're right. I find that interesting now that you just mention it, when I'm reviewing old documents or, just documents that clients bring in, I see that more often where they don't name a person to be in charge in the living will. And my question to you is, why would any attorney not do that in the living will?
I can give you a possible answer.
Why?
The Florida statutes gives us a form for a living will.
Right.
And when you look at that form,
It doesn't
it
include.
says it does not include names.
Oh,
It says
okay.
I leave it up to my family members. So why? Lawyer being lazy, copies the form out of the Florida statutes, says, hey, it's in the Florida statutes, must be good enough.
Okay, I bet that's it.
No.
It's not good
You
enough.
got to go to the next level and put in there and actually name who's going to make that decision for you. Most of our clients, if they're married, they're naming their spouse. And then as a second choice, they would name their children. And usually, and I'm literally talking about putting their names in it. And then if they're doing children, usually it's by a majority decision.
Right. Well, so let's take it a step further on this because it's very important for listeners to hear this and understand this and check their existing documents to make sure that it works for them. We want to make sure that it works for you, our listeners. Our living will, of course, includes everything necessary by the Florida statute. However, this work product, it's very important to us that we have created a work product that we know is the best for you, our listeners. So what have we done? What you just mentioned, which is we include obviously the specific people, whatever the relation to you, those specific people are the ones that you appoint to carry out your wishes. So we name that in the document. Further, what have we done? We have had our living will reviewed by several doctor clients of ours. And each time that we have done that, the doctors have also confirmed for us ours is right on. And that it's very important what we have done to specifically name those who you want to be in charge in that document. So ours has been reviewed by doctors because that's important to us so that we, again, make sure that we're giving you the best living will that you could have.
Yeah, and again, the living will is a
Pull the
document
plug.
where you ask, you don't want to be kept alive by artificial means, pull the plug. Often people will say, oh, Tom, well, I want a DNR too. And I say, look, the DNR has got to be signed by your doctor, but when you do your estate planning documents with the Olsen Law Group, we put everything in a notebook nice and organized, and under the tab for the living will, there's a one-page sheet on DNRs telling you, the client, what they are, what they're for, and how to get one from your doctor.
Correct. We want to give you that information, but there are 3 healthcare related documents in the state of Florida. One is a DNR that you must get from your doctor. 2 is a healthcare surrogate power of attorney that we can prepare. And the 3rd is the living will that we've just been talking about that we prepare for you.
Yeah,